Imagine this. You just landed your dream job, but a week later, your employee hands you a contract that could prevent you from ever working in your industry again, or keep you on the payroll without letting you work somewhere else. Sounds scary, right? Well, Florida's new Choice Act is about to make these agreements much easier to enforce for employers, and it could affect high-earning professionals like yourself. I'm Mitch Green, an asset protection and business law attorney here in Florida. Today, we're diving into the Choice Act, Florida's new law that dramatically strengthens enforcement of non-compete and garden leave agreements for high-earning employees. So what's new under the Choice Act? The game changer is this: for covered agreements that meet specific requirements, there's now a presumption that the agreement is enforceable. Previously, employers had to prove that the agreement was reasonable in order for it to be enforceable. Now, if you're a covered employee, you have to prove by clear and convincing evidence that the agreement is unenforceable, which is a much tougher standard. Courts are also required to issue preliminary injunctions against the employees who violate these agreements. So let's break it down. For both types of agreements, the agreement must be in writing and provided to the employee at least 7 days before any employment offer expires. No verbal shortcuts or last-minute surprises. Next, employees must receive at least 7 days to review the agreement before signing it. For example, if you receive a contract on Monday, your employer can't pressure you to sign it by Wednesday. You have a full week to consider it and seek legal advice. In the agreement, there must be written notice telling you that you have the right to consult an attorney. The agreement needs to also confirm that you'll have access to confidential information or customer relationships during your employment. Now, for garden leave agreements specifically, employers can require you to stay on payroll without working for up to 4 years. Yes, 4 years. Basically, it's paid time off where you can't work elsewhere without permission. If the employer wants to shorten your garden leave period, they must give you at least 30 days notice. Now, for non-compete agreements, non-compete restrictions can now last for up to 4 years. Previously, any non-compete more than 2 years was presumed to be unreasonable. Under the Choice Act, covered non-compete agreements benefit from a presumption of enforceability if they meet the Act's requirements, making them potentially easier to enforce than traditional non-competes. Now, here are important considerations. The rules apply to employees or independent contractors earning at least twice the annual mean wage of the Florida county in which the employer's principal place of business is located, which is roughly $100,000 to $120,000 in most Florida counties. An important exception, healthcare practitioners, as defined under Florida law, are totally exempt under the Choice Act. Additionally, employees not covered or agreements that don't comply with the Choice Act are still governed by existing Florida law, rather than the new Choice Act. Bottom line, if you're a high-earning employee or a business owner, now is the time to review any non-compete or garden leave agreement. If you want to make sure your agreements are enforceable or protect yourself from overly restrictive clauses, reach out to an attorney who understands the CARE Act. And for more updates on protecting your assets and navigating Florida's business laws, hit the subscribe button, follow, or get in touch with me. Stay informed and stay protected.